Sorry, misunderstood her.
And then Norma, where's the attorney on, what is his name? Greg Wright? All right, Cindy, I'm gonna try the link you've given
Wait
to
a minute, I
me.
just sent you the final one. 'Cause it wasn't opening for her. It has to start. ED. It wasn't, so I
All right,
fixed
I
it.
have it.
Now I've sent it.
Liners were gonna rest.
No.
Maybe not. Hold on.
Yeah. I can promise you we're gonna get to. start the June this
Well,
afternoon.
I was just asking if y'all, I mean, I was just saying, how many witnesses y'all?
I think we'll get, but we need to confirm something with.
Okay,
but
oh, I was
that'll be long.
just for logistics for us.
And we're deciding whether he needs to make it out.
Okay.
And
Call him.
he's,
This is true. I'm jumping
Call
the
who?
gun. Jumping the gun.
You're
and-
saying
and
by
he's
phone
a-
line?
well.
It's his
he-
decision.
he- Yeah, it's his decision and I wanted to think it, think it over. We can, I mean, I know what. I
Oh,
know, by the way,
It's been
by the way, he was there.
a great deal of time.
Just making.
Neither one of us had gotten any sleep and he was there until 11:30.
I just,
And I think he understands.
Okay. Okay.
And you know,
oh yeah. I don't necessarily deal with people like how y'all have to, but I deal with others.
All of this will make for great sitcom or stand-up comedy.
Like that, what's that? I used to love that show.
Yeah.
And like the old one. I didn't watch the new one. I've recorded it, but I haven't had a chance to. But I love that stuff.
Night Court's pretty good. Night Court.
Night Court. It's the original one.
Did you watch Jury Duty?
Which, no, I haven't.
Is that the one where one guy thinks it's real and everyone else
I
is in on it?
That's
God, it's so good.
That's just me.
Yes. Oh my God. It's like the worst nightmare of life. Like
Ethics.
it's got
Went to the restroom.
sure
Yes.
things, but he's like a pianist actor. He's just like he get drawn as an alternate, but he keeps on trying to like force his way in and stuff, and everyone and he's like trying to be like, well, don't you know? It's really good, and yeah.
That would be.
James Marsden comes in.
remember Jimmy Marsden. Oh, and George Brady.
Okay, Vashawn, you know what song was in my head this morning? Margaritaville.
All red show.
Yes.
So now, and Vashawn, that's for somebody who doesn't even drink.
And I
but
know.
it just sounds like a good song, people just relaxing on the beach.
I'm gonna take a moment to confer with council
Sure.
and provide him with some of the promised things that I had mentioned.
But Vashawn, I have tasted tequila before, and you know what's so funny about it? People were trying to tell me how to do it. And they're saying, oh, you need to lick your hand. I'm like, that's unsanitary. Like, let me go wash my hands first.
I thought the liquor will fill the drain.
Yeah, we should get.
And when we were in Scotland, you could go to different towns where they made, I guess they're known for their whiskey or scotch or whatever. And there's one town, I'm telling you, that entire town smelled like alcohol. And we're sitting there, I'm not going to tell the people who went because we were there for a international CLE. So I'm not going to mention any names, but we went to this distillery and it was beautiful. The flowers were beautiful and everything. So they were passing out free drinks to everybody. And the people I was with there, they were saying, yes, Stephanie, we'll take that. I'm like, thank you very much, because it smells bad.
Cool. All right. I mentioned. Okay. Yeah.
But we were in Paris. for CLE Bashan. And so money is flowing because it looks like play money. You don't even think of it as you're spending $300 a day, right? And so finally, we're sitting down to dinner and everybody has ordered their drinks. I was very fond of this drink that's sort of a lemon drink, but it's carbonated. And so they bring you these tiny glasses.
Yeah.
There's no medium, small, large, extra large. So I had ordered two. So the bill comes. And because everybody's spending $300 a day, money is starting to get tight. So we're sitting at the table dividing up the bill. And so
I'm sorry.
I say, whoever spent $40, the equivalent of $40 for drinks, you all need to pay your bill, right? And so we look at it and they say, Stephanie, that was you. Your two sodas were $40. Their wine, €2. And if only I were a drinker. But those were fun days. I've got to get back to Paris. All right, so we're just waiting for the jurors and waiting for your client.
Okay.
And they tell us it's a backlog, so. Bashan, have you started reading Fourth Wing?
I have not, Judge.
You have to.
I will. I just haven't had time to really.
I'm on book 2. It's called Iron Something, and my heart is racing because there's a lot of foreshadowing going on. Stop at the foreshadowing. So I'm like, yeah, it's called Iron Flame. Yes.
Check if I can add the Phoenix Jones Miller file drop down.
Yes.
It's here. Now what?
Lorraine Efron is supposed to be on her way here. And that way, so that person won't have to come back a second time since she's already here.
Yeah.
Thank you.
Yeah, all right, okay, thank you.
Where did she go? Did she go outside to call her attorney? Phoenix?
Ma'am, I'd be excused for a moment here.
Yes.
This is off the record, but I've talked to client, to able counsel. Whatever happens today, we're gonna be able to, I think we'll be able to charge the jury today. So that,
No, we're not going to charge the jury today because I'd like for a jury to have full day of deliberations. So we'll charge the jury tomorrow.
after the argument or before?
No, are you all calling witnesses?
That's what we're trying to decide. There are some issues with witnesses. I can go, I'll be happy to come back and go on the record.
Sure.
I want to be able to show the court that I wasn't making up this idea that there were photos on the cell phone. I did hear it from someplace and I want to show the court.
Oh, no,
I had a good faith basis. for
no,
that.
no, I'm fine with
No,
that.
but I think the record, ultimately, there may be some lawyer grade in our paper.
Okay.
I'm not predicting what will happen.
Okay.
Also, we have, and I've provided to counsel, snippets that show,
The basis for.
John, that John Hunter questions of the witness about Mr. Horace were made in good faith. He had a basis for that. And that witness, at least at this point, is unavailable. He was supposed to meet with us last night. I promised the prosecutor I would send him a summary of what the witness said.
Okay.
We now learn that there is a recording of what he said. Unfortunately, the witness has advised that he has retained counsel and he will not be available. He's going to invoke his Fifth Amendment.
Oh, well, who's the counsel he retained?
Pardon?
Who's the counsel he retained?
It's a civil lawyer in Houston named capital D, little e,
Well, have the
SIMON.
attorney appear by Zoom. And let's find out what's going on.
Well, we've been trying to contact him, but I can represent to the court as an officer of the court that I can't talk to him anymore, that I'm gonna assume that I think I have a right to rely upon his representation. He's gonna invoke his Fifth Amendment privilege. And therefore, I don't think we're in a position to offer the witness any longer. And as a consequence, and by the way, I'm gonna tender the court his name,
Okay, so,
his contact information, the
so let's do
lawyer's
it.
name, and I'm giving this to counsel.
all right,
the
so
lawyer-
let's do this.
Can I go to the bathroom?
Yes, yes, and we'll wait for your client to come out so we can have everything on the record.
And then we need to talk to him,
Okay,
obviously, about what he wants to do.
okay.
There
All right,
may,
and I'll give you all a chance to talk to him.
okay, because that will depend on how many witnesses we have, if any.
Okay.
I'll be right back.
All right.
I approach the court.
Yes.
Just hold up your finger.
Let
Thank you so
me
much.
look.
I've got you.
think y'all marked some exhibits yesterday, but you didn't give them to me because they didn't come in. So I knew, I might have seen two number 9, but I know you marked 10 and 11, but they never came in. So I think you're on 12. Yeah. I'm gonna look at one more place. to, like, put a-
Thank you so much. I'm sorry to.
All right, I see, the last thing I see, uh, Jerry is a defense 5. Everything else, I think, was for the record.
There's a 9 that came in.
There's a 9?
It's
Okay.
that,
And I believe there may be 2 exhibits that were not offered and we're trying.
this is the 9, Judge, it's the,
Ah,
that
So
transcript.
this would be 10.
No, I know he marked a 10 yesterday, just can't. But it never came to me. I was gonna,
Comes back around.
Yeah, 'cause
I'm
he
gonna
left too
make
soon
sure
yesterday.
that's fine and we'll start them. These are matters, Your Honor, for the record,
mm-hmm,
out of the presence of the jury
okay.
with respect to the witness who has invoked his Fifth Amendment privilege. And I have asked Joanna Collins, our investigator, licensed investigator. She's in the courtroom.
Okay.
The only reason she would testify is if there's some question of what was said.
Mm-hmm.
But I'm gonna represent that to an officer, as an officer of the court. If the state wants to call her, they can. But she has, she's been in the courtroom before, so
Okay.
she,
And what is the update on their client being brought?
that'd be-
Right, what's the update on Mr. McIntyre being brought?
I'm still waiting for him to be transferred.
What is going on at the Bear County Jail?
welcome, by the way, at least you don't have to wait a couple of hours on a Sunday, like John and I did, 2 Sundays.
Okay, all right,
They can't come here.
all right, thank you. I don't know what's happening.
He said it was the bailiff in the 187th who caused the problem.
Hey, we don't cause problems here. We solve problems. Let me speak to you in the back. All right, so everyone, I just let the jurors know that we were running behind schedule and it wasn't due to any actions of the state or the defense. And I informed them that it has something to do with the building. And technically it does, because it has to do with transportation to the building. And so I let them know that throughout the courthouse, there's an issue with the building. I just didn't tell them it was transportation to the building. So the court is calling 2019 CR 12495 State versus Taymor McIntyre. Can I have parties announced for the record?
Jason Garahan and Megan Galloway for the state bar.
John Hunter, Jerry Goldstein, Thomas Lane for Mr. McIntyre. He's present, Your Honor.
All right. So I believe there was something defense you wanted to put on the record.
Yes, Your Honor, but I believe we need to briefly confer with Mr. McIntyre, if that's okay.
Yes. So state, if you would just go in the back or either go in the back of the courtroom so that they can confer with their client.
Yes, Your Honor.
And to the media that's present, just make sure you're not recording their conversations. Mhm. Okay. Okay. That my metals are making its way through custom. Tomorrow, but they'll be here before Fiesta. Could someone let the state know? Thank you.
And then we have those preliminary minutes.
Okay, yes. And then if your client will sign the reset form. Thank you. Oh my gosh, baby dragon is doing well, right? All right, we're back on the record, and defense, you stated there's something you would like to put on the record.
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. If I may put for my seat.
Yes.
The court probably recalls the cross-examination, the able cross-examination by John Hunter of the state's witness, Joanna Reyes,
Mhm.
where he inquired of certain statements that she made, and the name Rashard, Rashard, Horace, Horace, to him, a boyfriend that she lived with for a period of time, I think a 1 month and a half in Houston, and was dating here in San Antonio. In that regard, the witness was supposed to arrive in San Antonio, told our investigator, Joanna Collins, who is in the courtroom, and she has been previously. She's a licensed investigator, and she's been working on this case with us for over 5 years. I believe. And I would represent to the court as an officer of this court that the witness, Rashard Horace, who had promised or indicated to us that he would be in San Antonio, meet with her at my offices here in San Antonio at 4:30. Late last night, I believe it was after 7 p.m., he contacted Miss Collins, our investigator, and advised her that he had retained counsel, and that he was not going to testify, that he was going to invoke his Fifth Amendment privilege. Based upon that, we were confronted with several issues. One, I believe under the Texas Code of Professional Ethics, rules of professional ethics, I believe it would be improper for us to continue to talk to him once he advised us that he had retained counsel. Secondly, it would be improper for us, I believe the law is clear, to call him as a witness to invoke his Fifth Amendment privilege in front of the jury. I know I would object to that at the state. Given those facts, we have been unable to reach his counsel, and I provided the state with, and I would offer to the court what has been marked as Exhibit 12. I would advise the court that Exhibit 11, which has also been tendered to the state, and I believe one of the able counsel has listened to it. The Ms. Collins advises that she didn't realize that when they called her office instead of her cell phone, that there was a recording. And so we have a recording of her conversation with him, which is important for purposes just of the record, not before the jury. But I would offer defendants exhibit 11, which is the recording of the conversation between Joanna Collins, the licensed investigator, and Mr. Horace. And I have tendered it to counsel, and I would offer that solely for purposes of the record.
All right, so if you could label that so there's no confusion, D11R and D12R.
We
Just add the letter R.
defense 11R
Yes.
and defense exhibit 12R, which I've also tendered to counsel, is the name Richard Horace and his telephone number, which we are not calling because he's represented by counsel, and his attorney, which he advised us of, Donald D. Simone, D, small d, little e, capital SIOMONE, with his telephone number. We attempted to reach the attorney last night. Did we call him again today?
No, I left a voicemail, both my cell phone and yours.
We
Jerry,
have not heard
schools.
back from them, but as an officer of the court, I don't think I can move forward when somebody is advised that they've got counsel and they're looking. As a consequence, we will not be offering the witness, but we wanted the record to adequately reflect what I think shows good faith. First, I have what's been marked as defendant's exhibit 13R, which is an excerpt which I provided to counsel sometime earlier today, I think, maybe an hour. And I had made a statement to the court with respect to the alleged child pornography. And I said it was on a cell phone, and I was corrected. I knew I saw it someplace. It is in the recording, and I would tender and ask that it be admitted for the record purposes only, 13R, Your Honor, in which the witness, potential witness, Mr. Horace, tells our investigator
Oh, and
that-
counsel, with regards to that, because the court is aware that there are certain connotations with regards to any offense of that nature. If you just want to admit it into the record, it's in the record.
just, I wanted the court to know that I was making a good faith.
No, I appreciate that.
about what I thought.
All right.
The statement on 2 counts. One, when I said that I was in error when I said it. Now I withdraw that. I want to show the court why I said it. Secondly, Your Honor, I would offer defendant's exhibit number 14R. And it is, Your Honor, it is the excerpt that show the basis for the specific questions that Mr. Hunter asked of the witness, Joanna Reyes, the state witness. And it's being offered for the purposes of demonstrating that he had a good faith basis for asking those questions. We anticipating that we would have the witness, which we do not. We're not asking this to be presented to the jury, but I think it is important that the court knew that we didn't make that about the whole point.
Okay, so I will tell both parties in looking at 13R. So they're saying that some pictures were found inside a camera. Were there pictures found inside of a camera?
No.
In
The
fact,
camera
the
was never
camera was
found.
never recovered.
Well, by the way,
so-
Let's say we're cell phone.
It says cell phone,
All right, so,
and that's
With
what
re-
I said.
all right, so with regards to defense 13R, nothing was ever taken from the cell phone. So it appears that if somebody was saying that there was something in a cell phone, I don't know if that was interrogation techniques or what, but do both parties agree that there was nothing, no photos pulled from the
We have
complainant?
no idea. It was never done.
No, there's no evidence of that, Your Honor.
That there is no evidence because nobody was able to look. Now, it's offered not for the purpose of the truth of the matter, but to show why able counsel asked those questions, because we expected that witness to say that that's what she said, which
Alright.
was contrary to her testimony.
Well, and
Yes.
if I can respond to that, because I've listened to the recording and what is alleged is that the state told the witness that illicit material was found, which is wholly untrue.
But by the way,
So
we're
That's not really.
not offering it for the truth.
All right,
We're just offering it to show the good faith basis for the question.
okay, so this is, we're gonna have one person at a time.
I'm sorry. Your Honor.
I'm listening to everything. So, I have some questions and then we can talk about defense's exhibits. Are there any other exhibits, defense?
Yes, Your Honor, there is, I believe it's 14 R, which is the basis for Mr. Hunter's questions. If you're still speaking about the photographs on the cell phone, which is, I think, what counsel was alluding to.
Okay, so, the only evidence that you're offering in for the record is 12R, 13R, 14R, and what is the?
11 R.
And 11R, is that?
11
correct?
R is the total recording, Your Honor,
Oh,
which has
okay.
been provided to the state.
All right, so anything else that's being offered into evidence for the record?
Yes, Your Honor. The basis for Mr. Hunter's questions.
No, I mean, do you have any other exhibits to be offered into the record?
No.
All right, so, oh, and counsel, you can remain seated. It makes it easy for the court reporter to hear. So I want to take these matters one at a time. All right, with regard to this witness, Mr. Horace, was he subpoenaed?
No, Your Honor, we didn't learn about him until he called Mr. Hunter night before last, emailed him. And Mr. Hunter appropriately said, I can't speak to you. I'd like you to speak to our investigator. And that's when the conversation the next day happened between Miss Joanna Collins and the witness.
All right, and I'm assuming the email contained information that you thought would be relevant to this case.
No, the email that we're talking about, that he said I'm retained counsel.
Your Honor, just to clarify,
Yes.
the email contained a photograph of Mr. Horace with Ms. Reyes, which was tendered to the witness as defendants 10.
Mhm.
And we asked the witness to identify the individuals depicted in the photograph, and I believe the witness testified that that was her ex-boyfriend and her. And he indicated that he had information about the case, and that's why we directed him to our
And-
investigator.
All right, so what date was this? That
Day
he,
before yesterday.
so we're saying this was Tuesday?
The initial contact was made on the 8th.
Okay,
And understand that we're not offering this to put it into evidence. We're offering it to show the good faith nature of his question.
so, all right, so I understand that. So then you all had no intention of calling him as a witness?
We did.
Well, we would love to, but he has advised us that he's invoking his Fifth
So-
Amendment privilege.
Well,
And
this
what
is,
I'm advising the court is that we're gonna honor that. And since we can't contact him directly, unless the court wants to continue this case and
no,
not.
let's call the attorney. It appears,
We've been
uh,
trying, Your Honor, if the court wants to try.
all right, just give me a moment.
Sure.
And I'm assuming it's this law office that handles civil So what I have done, and there was no objections from the state or the defense, I've informed the jurors that we will start at 2. That will give us some more time to make sure everyone has what they need. So the court has in evidence for the record Defense Exhibit 11 for the R, Defense Exhibit 12R, Defense Exhibit 13R, and Defense Exhibit 14R. And both the state and the defense went to chambers with the court. Neither party had an objection to the court reaching out to the attorney. Is that correct, both
That's
sides?
correct, Your Honor.
Correct, Your Honor.
All right. The court did leave a message. My understanding, that attorney is in depositions. Their depositions started at 10. They anticipate the depositions will be over with by 11. And one thing I can say about the civil side, when they do time announcements, their time announcements are exactly their time announcements. If they say it's going to be an hour, it's an hour, it's not more.
That's fine.
So with regards to the defense exhibits, I don't know if y'all want to wait and come back at 1:30. I'm telling the jury to be back at 2. So at 1:30, we can see what the results of are with the attorney and with your potential witness.
That's fine, Your Honor, and we'll be at, I'm not gonna go anywhere, so I will be here in case they call back. We can do what the court suggests. I'll have my counsel. I would like to advise the court
Mhm.
that when all this is over, so you have some idea where we're going. All we're offering it is to show that we made, that it was a good faith, those were good faith questions.
Mhm.
I don't think that's gonna be an issue. The second thing is whether the state has the opportunity. This just relates to the question, other than the one with respect to the photo, to the questions that Mr. Hunter asked. I am asking the court to consider when this is all over with, if we don't have a witness, that the state not be allowed to argue or infer that we were somehow dilatory or not being honest in not in asking those questions and not having a good faith basis for them.
Oh.
If that's the case, I believe I'm being made a witness in this case, and I'm gonna have to move to withdraw it.
All right. So what I can say is with regards to Defense Exhibit 13R, it appears that this is some sort of hearsay within hearsay, because it's saying that it's alleged that the witness is saying that a district attorney and a private investigator told her something. And it's not a statement that, it doesn't appear that it's a statement that she made. It
No,
appears.
that's with regard only to the photos, and that's not the issue. The issue is with respect to the questions that Mr. Hunter asked. The photos didn't come in and the court admonished the jury at length. And as opposed to our instruction, she admonished them at length not to consider it. I just wanted to show that I had a reason to believe that I said it was on the phone. What we're talking about is the questions that Mr. Hunter asked. And we used his name because we thought he would be here. And I believe we're entitled to, since the witness denied it, and we don't have a witness to rebut it, all we were offering the statements for is her statements that are exactly contrary and mutually exclusive with what she testified on cross. And if all I'm saying is Mr. Hunter had a good faith reason to ask those questions, and we shouldn't be put in a position of, if we're doing it in good faith, making it look like we didn't make any efforts to produce the witness. We're availing ourselves of the able courts process. If we can get it, great, but otherwise I don't think we should be made to look like we didn't offer. There were witnesses that they said are out of the country they can't get, who are material. She was the head and senior CSI officer. Can we argue that they are responsible for her not appearing? I'm just saying that.
I think legally you can argue that she didn't appear.
Okay, I understand that. I'm concerned that
Your Honor, if I.
that it's going to look like us, and it deals with our credibility, that we misrepresented the fact that he said that. And since they're not gonna be able to see that he did say that to us, I wanted to be sure the court knew we had a good faith reason for it. And I don't think that we should be punished for that. I think we followed the ethical rules, and I think it puts my credibility and Mr. Hunter's credibility and ethical consideration. We got the wife of a very well-known lawyer in this town on that jury. I don't want my credibility or my ethics to be put in, and I think they've created a problem for me. All I'm saying is, as long as they don't say that, look, they asked those questions about this guy and he didn't show up. He's entitled, if he's gonna invoke his Fifth Amendment privilege, let's have him invoke it before the jury.
And Your Honor, just very briefly, if I can add a little addendum to what Mr. Goldstein says, and this can be discussed more at the charge conference. What I think Mr. Goldstein is urging is that there would be limitations on what the prosecutor would be entitled to argue based upon that portion of Ms. Reyes's testimony, in the sense that, that there is a curative instruction that would be perfectly reasonable, that would apply to both sides, that can be given, which is to simply instruct the jury on the function and the purpose of Rule 613 in the charge, and to explain. You have heard statements in the course of this trial that are attributed to witnesses, some of which were adopted and agreed upon, and some of which were denied. You are to understand that any such statement is not being offered for its truth, but merely to confront the witness about whether or not they said it. And it is to be considered by you only in determining whether or not you find the witness credible.
I'm not putting that in a jury charge. Here's the thing. You all question witnesses. You all make your objections. I make a ruling on those objections. The jury, I don't believe, is thinking, oh my gosh, is the defense or is the state saying something that is untrue? The only thing they know is an objection was made and the court ruled on the objection. Either I sustained it or either I overruled it. I don't see how 613 comes to play in the jury charge. And I think we're moving far afield of defense's exhibit state.
I believe we're entitled, and I would re-urge now, and I will, if the witness testifies, we don't have to worry about it.
All right, let's
If-
cross that bridge when we get to it. Because we're
I'm happy to wait. I
All
just
right.
want to give the court notice, and I want counsel to know that if the witness is not going to testify, that we made our reasonable efforts and fulfilled our ethical obligations to our client. And I believe that puts my credibility in issue and John Hunter's credibility. And I'm going to move to withdraw. I'm not going to have that jury have the idea that somehow I'm engaged in chicanery.
It would be, I mean, what we're discussing, Your Honor, would be the issue of, while the prosecutor is well within their right to say that those statements were offered.
okay,
not
here's
for
the thing. You all are talking about a jury charge. We're not at a jury charge state yet. The only thing we're at right now is, do you have any witnesses? It appears that you wanted a witness here. That witness is stating that they've retained an attorney. You all have tried to reach the attorney. You all have agreed that the court could reach out to the attorney. I'm telling you, the attorney is in depositions, started at 10 a.m. I'm being told that those depositions should probably last for close to an hour. I left them my cell number. They're going to zoom in. When they can zoom in, you all will have a chance to speak with them. But so both parties are aware, and this was an assistant. I'm assuming it's the assistant to the attorney, which it's hearsay, double hearsay, but she says they do not represent him in anything other than a civil matter. Has to do
Doesn't
with
mean
an
we can't
accident.
have a conversation
So,
with Mr. Hart.
yeah. So that's all we're doing. We're not arguing the jury charge, what comes in, what stays out.
And the real question is whether he's doing it on advice. If it's not on advice of counsel, then I'm entitled to talk to him.
Well, we're
And-
gonna
and-
find out.
And more importantly, Your Honor, regardless of that, I want to talk to him. But if he invokes his Fifth Amendment privilege, that ends my ability to deal with him unless the court wants to challenge whether he has that right. I'm happy if the court instructs me to, if he calls back and he invokes his Fifth Amendment privilege, to have him testify before the jury, question by question. And he
Yeah,
can-
what will end up happening, if you think he's gonna invoke his Fifth Amendment rights on every question, then we can have a hearing outside the presence of the jury and see if that's the case. So other than this witness, maybe, are there any other witnesses?
It would depend on whether that witness testifies, but I can assure the court it would be short and that we're not gonna have more than an hour and a half to maximum 2 hours of testimony or at the max.
All right, then state your response.
Regarding defense exhibits 11 through 14R, I take issue with the fact, good faith argument, okay, because the question that was asked by Mr. Hunter to the witness, Joanna Reyes, was, did you tell Mr. Horace that you personally observed child pornography on the
But
camera?
that's not the one that we're.
Well, no,
talking about.
so, all right, so, both parties. I will allow both sides to put ever what they want to put in the record. So, once the state's finished, then defense, if you have some response, you can respond. State wants the defense response. If you have some response, then you can respond. So state,
The witness denied that because the witness never told that to Mr. Horace, and
Well-
he in fact did, let me finish. In the recording that was provided to me by defense counsel, Mr. Horace explicitly states that Ms. Reyes told him that the state told her that they looked in the phone and there was some examination on a cell phone and that there was child pornography. That is absolutely not true. The phone was never examined and there is no evidence at all of the child pornography. And so at the time, it's untimely now, but it was improper impeachment by Mr. Hunter that I couldn't object to because I was just provided this recording this morning. And so that's what I want the record to reflect.
And if I may respond to that, Your Honor, since that issue is directly pertaining to my question. As Mr. Goldstein explained, we did not have the benefit of the recording when the questioning was done. I had the benefit only of rough notes from the investigator. Secondly, I think that the prosecutor's argument misapprehends the basis of Rule 613, and we've made that record as explicit as we can. And I understand that there's disagreement, but we stand on our papers.
Then it's not offered for the truth, Your Honor. It simply was offered to show a prior inconsistent statement. And that all I'm interested in,
well, no, because from what I'm reading
yes,
is that according to the video that you all have given the state access to,
it's
And
an
that's
audio,
been it.
Your Honor.
and that's audio,
It's an audio.
all right, the audio and that what's been admitted for purposes of the record, I guess it's D11R.
It's the 11R.
All right, so in it, according to what's been transcribed, the witness never said that she saw the illicit material. She's saying that a district attorney and a private investigator pulled her in the room and said, this is what we saw.
Which we didn't have the recording
No,
at the time that, so.
And
and I understand that. And what I'm telling you both is, I am not saying that either party has done something untoward. I'm not saying
State
that.
has. I mean, that's the implication of what
No, what
counsel
she's-
is saying, is that we have done something.
All right, so here's the thing. All of you all are attorneys. I don't think anyone is going to do a closing arguments and say these attorneys are unethical. It's not allowed. State, do you have any intention in your closing argument, and I don't want to go into great detail, of saying that these attorneys are unethical?
It's not allowed, but it's evidence, Your Honor, so I am.
So that would be a no. So I don't understand why we keep going about being unethical and whether or not a jury thinks we're unethical, because you all make objections, both sides. I make my rulings on those objections. The end.
Well, no, if an argument's gonna be made that we failed to call the witness, then we're gonna ask to reopen. And if we're not allowed to, I think it does imply that we did something in terms of not calling the witness. And if the witness insists on their Fifth Amendment privilege, I think that puts us in a bind, an ethical bind. And I'm simply not gonna have this jury believe that I did something like that.
You're not the person who even asked the question. Your co-counsel, is your co-counsel going to withdraw because the jury will think that he did something unethical? Because your co-counsel is the one who was cross-examining the witness about, what the witness may have said. So if someone is saying that they're going to fall on their sword and withdraw, then it wouldn't be you. You didn't ask the question.
Well, you're just like the prosecutors.
Hold on.
they're-
There are two issues at play. The first is that the implication of what able counsel for the state just remarked about is, I think, plainly an indication to the court of a plan to strike at the defendants over the shoulders of counsel.
I,
And secondly, the way in which this process is going forward is attempting to drive a wedge of conflict between the defendant and his counsel, which is an issue under Strickland versus Washington. And it is a problem that has deeper implications.
All right, so let me give you all the deepest implications in this case. You all ask questions, people make objections. I rule on those objections. And you all can accept my rulings or not. But what I am telling you is, one, I expect everybody to follow the rules of evidence. I expect everybody to follow the rules of professional conduct. And if you don't follow the rules of professional conduct or the rules of evidence, that's where I step in. Now, if somebody believes that there's a wedge between them and their client, then file a motion. We are not here at this juncture to talk about the charge and what will be in the charge and the arguments that people can and cannot make. If you all want something specifically, and this goes for the state or the defense, that somebody is not allowed to argue, then file a motion. That's what I can tell you. That's the way it should be done.
We will do so. Thank you.
Now, other than this witness who may or may not appear and may or may not be available, are there any other witnesses?
There is before the court, and I believe it's been marked as 14, Your Honor.
14R?
14R, D 14R.
Yes.
It is that clip from an Instagram from a Miranda Hubbard. I will tell you that it was at it's YouTube, Your Honor. And I'm not sure of this with this game. Can you tell that from this? Anyway, it is before the court. Counsel has a copy of it.
I don't have a copy of it. What is
Well,
it?
it's in that, I put it, I offered,
Not yet. Which
it is marked.
It's marked, but you haven't given it to the judge.
I believe we have. Yeah, can we?
No, I
all
only
right.
have
14R.
12,
It is
13, and
14R,
15.
Your Honor.
No, what was that?
That would be 15R.
No,
You gave it.
let me see, may I see 14R, Your Honor?
Sure.
Right, then this is 15R, thank you.
And I'm sorry, let's go off the record for a moment.
thanks for calling Simone Law.
For the record, with respect to defendants exhibit 15R,
All right, what is defendants 15R?
that is the.
We're
And
not done, state. Sorry.
sorry,
I thought we were done, but
I
we're
know.
not. No, no problem.
He called when we were. This is the reply. Is this YouTube?
I believe it's YouTube, but
It
you saw
appears
it.
to be YouTube.
Let me see.
And this, the first page is a cumulative exhibit D 15R is the comment that was on it. The second is the.
Okay, may I see
person that
that?
made it. I just want the record of like what you're getting.
Okay.
And the last is a list of calls. The first five, Ms. Collins, who is listening, and she can correct me if I'm wrong. She called last night. The rest of them, she's either called and she went by residents who have connected to this woman. as well.
Sure. No problem.
Thank you. This is all about it. This is all about it.
So none of those are admitted, Judge, right? They're just.
Being to look at lawyer, if I just blew it off. When somebody said, "Oh,
All right, so are you telling the court that this is the person you want to call as a witness?
if we can reach her, Your Honor, we're still trying.
We've seen it, Judge.
They've got a copy of it.
All right. Is there anything else?
We're still trying to reach her, Your Honor. The court asked us, did we have any other witness? I wanted to show the court what we're trying to do because I got an email last night at, I think it was 11 o'clock, telling me to, hey, you ought to look at this thing because I don't read those comments.
All right, well, it says here that the witness is a cashier, so everybody knows where she's employed. Just go subpoena her.
Do we know, can I ask?
I mean, no, that's what it says on the exhibit that you gave me.
Well, that's what she said, not what I'm saying. Can I find out whether perhaps we've already explored that? May I ask the?
Sure, but
investigator?
what we're gonna do is we're taking our recess now. You all need to be back here at 1:30.
Sir.
All right.
We just maintain that there's still problems with court has done that to a court has done that to accommodate our objections. We just maintain that there's still problems with these recordings, even though they are redacted.
Okay.
So I mean, I think that the record we had yesterday was pretty thorough about it, and it will be evident when I say that. And
And the way we left it, Your Honor, I think, is that the court had asked her to redact it. And we are no longer arguing is that they've rested. We're gonna
Okay.
say, let them do that with our objections, and the court doesn't need to rule again. We can rely on the court's ruling.
Okay.
Okay, then we're all good.
All right. All right. Do we have all the jurors here?
Yes, take them again, right?
Yes.
Are they in that room, Judge, right back there?
Yes, they're down the hallway in
When
that
I
jury.
go to the restroom, I do want to tell the court, I walked to the restroom during the lunch break and the door was open. And I'm sure they saw me. I didn't look in, but it dawned on me when I walked by it
Okay.
that they were in there, and then I walked back by, but I,
Okay. Oh, that's no problem.
well,
And they already know that nobody's going to speak to them. So.
and you know, when you're standing outside waiting for somebody to give you a ride,
Mhm.
I try and stand as far away from them as I can, but
It happens.
it's not that big a place.
All right, we're going to go on the record in 2019 CR 12495, State versus Taymor McIntyre. Could I have parties announced?
Megan Galloway and Jason Garahan for the state of Texas.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre, Your Honor, he's present.
All right, are both parties ready to proceed?
The state's ready, Your Honor.
We're ready to proceed.
We're ready.
All rise for the jury.
Everyone, please be seated. And I believe there was a discussion and there was no objection. State you wanted to briefly reopen for 2 exhibits.
Yes, Your Honor, and at this time, the state offers states 118 evidence.
Okay, and I'm sorry, 1 exhibit.
1, yes, Your Honor.
And that states exhibit 118.
Correct, Your Honor.
All right, defense.
Your Honor, we renew our objections from yesterday in full. We also take exception and object to the court's ruling.
All right, the objection is overruled. States exhibit 118 is admitted.
Thank you.
All
We
right,
rest, Your Honor.
and defense,
The defense rests, Your Honor.
state, do you close?
Yes, Your Honor.
And defense, do you close?
Yes, Your Honor.
All right, thank you. So, ladies and gentlemen, you've heard all of the evidence in this phase of the trial that you're going to hear. What is going to happen is I'm going to have you all come back on Friday at 9 a.m. And at that time, I'll read to you what's called the charge of the court, which is the jury charge. And both the state and the defense will have a chance to present to you their closing arguments. You have not been given this case to begin your deliberations, so you are not to think about it, talk about it amongst yourself, deliberate with yourself, or discuss this case with anyone, or do any type of investigation. If you see anything about this case, you're to ignore it. Does everyone understand? All right, so we can go off the record. And I know sometimes people may need medication. So if there's some medication that you may need, and when I say medication, I mean, sometimes people forget to bring their blood pressure medication for the day or something of that nature. So if you have that, please make sure that you bring it tomorrow, because once you all begin your deliberations in the jury room, no one is allowed to speak with you. Everything that, any questions, I should say, that you may have, or any any questions that you may have, or any communications, that will have to be done in writing. So if there's some type of medications similar to that, because we're going to be starting early in the morning at 9, just make sure you bring those. And if there's some medications that you have that you need to eat with food or have on an empty stomach, just let us know. Any questions before I excuse you? All right, so enjoy the rest of your day. It's turning out to be a little bit hot outside, but I think it's still beautiful. All right, everyone, please rise for the jurors. All right, defense. The state filed a motion.
Enjoy more of our videos on the Community Advocate Network channel, and don't forget to like, share, and subscribe. If you would like to advertise your service, special announcement, or event, you may contact us at the Community Advocate Network at gmail.com. For community resources or services, visit our website at www.canmichigan.com.